Okay, okay. So, hi everyone. My name is Marguerite Bourke. I'm a lawyer with TBA Law. I am an accredited family law specialist. I've been practicing law for over 30 years, primarily in the area of family law, but I've also got a fairly good general background, understanding and practice of the law. So today we're here to talk about family law, what you need to know, divorce, ways to settle out of court, four-step process, and other key elements. I just want to start by talking about intervention orders, especially since everyone is cooped up together and they're very challenging times. So if anybody is concerned for their safety, they should consider what they can do to ensure that they are safe. Depending on the extremity of the situation you're in, you either call the police, otherwise you can go to your local magistrate's court and apply for an intervention order. If the children are exposed to violence, you can seek to have them included on that order. So I just thought I would mention that before we move on. So generally when we talk about divorce, we're talking about dissolving the marriage. However, a lot of clients seem to have a very general view of what divorce is, and that when they talk about wanting a divorce, they're talking about settling the property and what they're going to do with the children and any other issues that are involved. So I'm just going to talk about divorce and dissolving the marriage because some of you may be interested in that. The grounds for divorce are irretrievable breakdown of marriage. The evidence required is 12 months separation. There is no exception to that, regardless of what you've gone through. When you apply for a divorce application, and if you meet the criteria, the court have to be satisfied that any children in the home, whether they be your children or other children that are living there, that their care, welfare and development is being attended to. So that's basically a divorce application and what you need to prove. So I'm now just going to touch on parenting issues. So when you can be separated under the one roof, you don't have to have a physical separation out of the house. But once there is a physical separation and there are two households, if there are children, then you need to make arrangements for parenting arrangements about where the children are going to live and how the time is going to be divided. And I'm just going to touch on this issue. So a lot of separated parents are able to make their own arrangements for parenting. However, there are, I guess, two fairly broad categories of cases. There are those cases where there are protective concerns for the children. One of the parents may have drug and alcohol issues, anger issues, etc., etc. And in that sort of situation, you may not be able to reach an agreement. Where those concerns are not present, then hopefully you can sit around the table and work out the parenting arrangements. If things get a little derailed in those conversations, you can attend a family relationship centre with the mediator, and they will assist you with your parenting arrangements. Any arrangements that you make need to be practical and workable. If you reach an agreement, a lot of people just will have a verbal agreement. Some people will write it down. If you have a verbal agreement and you both sign and date it, that becomes a parenting plan. None of those types of agreements are enforceable. If somebody doesn't stick to that agreement, there's no stick, there's nothing you can do to enforce it. So if you're in a situation where you do need a bit of a stick and you do need to enforce that agreement, then you need court orders. And there are only two ways to get court orders: by redrafting your agreement into an appropriate legal form and posting it to the court and asking them to make court orders, or going through the litigation process and having a judge decide what orders would be appropriate for your family. Now, you can only go to court if you've attempted mediation or been to a mediation centre and have had them decide whether your case is appropriate for mediation. Some cases are not, and they're generally the high-risk cases or where there's a great power imbalance. So the Family Relationship Centre or a family dispute resolution practitioner will issue what is known as a Section 60I certificate, and you need that certificate to go to court. Once again, there are some exemptions to that, but generally that is the pathway to court. Now, I'm going to move on to property. So, with property, you can apply or start your property negotiations at any time. For practical reasons, most people don't need to do that until they're separated. So you don't need to be divorced. A lot of people think you've got to be divorced before you apply for property. All the limitations for attending court are after you're divorced, or if you've been married, you've got 12 months after your divorce to go to the court and ask them to make property orders. If you're in a de facto relationship, you've got 2 years after separation before you can go to the court. If you're out of time, there is a provision where you can go to court and ask the court to still hear the case although you're out of time. However, that is a further step that you've got to do and adds to the whole cost of the process. So it's always good to be mindful of that. In the family court, when judges are deciding property, it's what is known as a discretionary jurisdiction. Family law property divisions don't follow a mathematical formula. There are provisions in the Family Law Act that sets out what must be considered, and there is case law that discusses how the law has been applied and what the principles are. So for your property settlement, you can have been married, you can be de facto, you can be same-sex. So some parties might feel that the marriage isn't going or the relationship is not going well, and they might start putting into place a bit of an exit strategy well before the separation. And I think most people seem to know when this might be happening. Often I'll hear clients say to me, you know, my husband or my wife, they tell me nothing, they run all the finances, I don't know what we have, everything is done online, I don't know the password. So in those sort of scenarios, and if you think somebody is heading towards a separation, I would just suggest that you're fairly vigilant about if any letters arrive from banks that you don't know about, maybe open them up, get a photocopy, try to find out what information you can before the separation, because in those types of relationships, often at separation, someone will remove all the financial documents. And there have been situations where before separation, one party has taken the hard drive to be copied so that maybe later on they're able to access it. So there are some strategies you need to be aware of, even before you separate, if you think things are going belly up. And that's probably quite a good time to maybe get some advice, because every situation is different. Before you start your property, at the beginning of the property process, the Family Law Act and the Family Court have what is known as a pre-action procedure. The Australian government want people to try and attempt to settle their cases. They don't want people going to court. That should be a last resort. So there's a whole pre-action procedure that you can go through, and they want you to try and attempt to mediate. And before you can go to court, you need to have followed this procedure. There's a lot of brochures that the Family Court have put out talking about this procedure. And this basically is where each of you should provide full financial disclosure about your financial situation. Now, in some relationships, as I mentioned before, there may be one party that's less than forthcoming about what they have, and there may be concerns they've hidden assets, and you may not know much about what the financial situation is. And even though there are obligations to provide full financial disclosure, it's very hard to complain that somebody hasn't done that if you don't know what's there. So, that can be an issue that plagues the whole case. And we'll talk about that a little bit further on. So in the disclosure process, the first thing you've really got to do is work out what there is, what property you have. So that can be a very simple process or a simple exercise, owning a house, a car, furniture, is pretty black and white. However, it's not always a simple process, and I'm just going to touch on some areas of complexity so that you sort of can turn your mind towards these things. Often parties in the relationship have received money from family members to help them set up a house, buy a house. So the issue is often, was that advance a loan or a gift? Quite frequently, there's a dispute. So just say the parents of, say, the wife advance $50,000 at the settlement. Later on, if everything goes belly up, it may be argued that that was a loan. So the court would have to determine that issue. And once again, this is something you need to get some fairly early advice on, because you need to work out what your position and strategy is in relation to that advancement. And obviously it depends whether that advancement of money was made 20 years ago at the beginning of a long marriage, or 6 months ago at the beginning of a very short marriage, because it is all going to depend on what evidence there is about that advancement. If you're in a situation where your family are advancing you money now, but you're still in the relationship. But the relationship is perhaps rocky. You might want to think about documenting that as a loan. Depends on the situation. Another issue might be some lottery winnings. Who bought the ticket? Who owns those winnings? So there's another category of what might loosely be called property, but it's actually called resources. So you may have a personal injury case and expect to get $200,000. You might have goodwill in a business. You might be a beneficiary in an estate where the testator no longer has capacity but is still alive. So there's they can't change their will, and so that money is kind of sitting there, but you can't access it because the testator is still alive. And there are also issues about money that is no longer in existence. There may be gambling debts or money that was wasted during the relationship. How are you going to deal with that? So when we're looking at property, we look at what you have and also the debts. So it's a balance sheet. And then we try to work out, after taking all the debts away from what you own, what the equity is. Sometimes that is referred to as the pool. Now, after that exercise has been completed, we look at how you got this money or how you got this property. And the court will look at direct and indirect and financial and non-financial contributions. So if it's a long marriage and you started off with nothing, there's this concept of a partnership of marriage where you do different tasks, but you're working as a team. You might have kids. And in situations like that, often it's agreed that the contributions are equal because the homemaker contribution is valued by the court and it is set out as a significant contribution in the Family Law Act. There are other cases known as big property cases, where one of the parties has made mega millions of dollars, and there was a period in time where those contributions were given a greater weight, but that is perhaps not so much the case now. So contributions can be a complex area, and I mentioned previously the situation where money had been wasted. That money may be added back. So add-backs generally only happen where there are fairly significant amounts of money involved and very strong evidence. The court will not add back money as a matter of course, but that is something to be aware of. So after you've worked out the contributions, that may be a tricky thing in your case, or it may be simple. They then look at a number, they then look towards the future and what the future holds for both of you. And these are known as Section 75(2) factors and include such things as your age, your health, your income earning capacity. Some people stop working after a separation, and that may be because they've had a nervous breakdown, or it may be because they think, well, why should I work at the moment? I think I'll just go on a holiday. That's called a lifestyle choice. And so it may well be, that's why we look at their income earning capacity and not their actual income. whether you're looking after others, so and what the standard of living is. So all of these factors look towards the future and what the future holds for each of you. So if the contributions are considered equal, in a lot of, I guess, more traditional families, and especially historically, mum may have been a stay-at-home mum with 4 kids. Dad was out advancing his career. Mum didn't advance her career, and now that the marriage is over, she's looking at maybe working in a fairly low-paid job, whereas Dad might have zoomed ahead with his career. So in situations like that, the scales get loaded towards the homemaker with a very poor future expectations. You know, that's another balancing exercise that the court has to look at. Now, once the court has done that exercise, or during the negotiation process you do the same exercise, you then sort of have to stand back and look at the bigger picture. So it may well be that one of the parties is left with, say, 4 young children, and if you looked at things in a fairly strict clinical way, it may well have been that she may have had to leave the family home. But looking at the bigger picture, the court might say, well, look, I would have divided things on a 70-30 basis in favour of the mother. However, because she needs to keep the home, I'm going to award her 73% or whatever, which will enable her to maintain home and hearth. So at the end of the day, the court will make an order that it considers just and equitable. And so that's why when you're negotiating a property settlement, you're looking at the bigger picture all the time. And you've got to balance and juggle and advocate for your client's position. And you can use all of these matters that we've just talked about to advocate for a better position and outcome. But once again, looking at the bigger picture, it's best in most cases if you can settle. Litigation is very expensive, it is uncertain, it is a discretionary exercise by the judge, and sometimes you might receive legal advice that you know, the offer that you're that has been made to you is a little low, but if you accept that offer now, you've got 1 in the hand rather than 2 in the bush. You've got some certainty now, and you don't have to pay legal fees. You don't have to go through maybe 2 years of litigation. And all of those things need to be weighed into any decision you make. And any decision you make needs to be made with your eyes open, because generally you will only get 1 bite of the cherry. A lot of people settle and have settler's remorse. So these decisions need to be made very, very carefully. Now, if you do reach an agreement without litigation, you can either enter into consent orders, which need the court approval and require a whole lot of forms and documents to be drafted, or you can enter into a binding financial agreement, which does not need court approval, but once again requires a whole lot of documents to be drafted. And the reason we either enter into consent orders or binding financial agreements is to close the door, so that after you've perhaps verbally reached your agreement and put everything in place, the court still has jurisdiction to hear the case if one of the parties decides later on they want to have their bite of the cherry. So we're closing the door so that that won't happen. There are some circumstances where court orders and binding financial agreements are overturned, but we're not going to go into that scenario today. I just quickly, before we finish up, want to talk about spousal maintenance. So spousal maintenance is set out in the Family Law Act, where payments can be made to a spouse for their support. The test is whether the payer has the capacity to pay and the person making the claim has the need. And spousal maintenance can be by way of periodic payments or lump sum settlements. It can be done as part of your general property law case, but it can be a discrete application of its own, and you can make an urgent application. If you are making such an application, the court will not take into account any Centrelink benefits you're receiving, because there is a public policy behind a spousal maintenance application that says support should be provided by those within the family first before looking at the public pocket. So if you're in that situation, I'd suggest you come and get some legal advice. So I think that just about takes us to the end of this little discussion that we're having. Well, it's really a one-way talk. So I hope you've all got something out of this. Today's talk is obviously just general, it's broad brushstrokes. I guess it's to let you know that, so many clients come in and say, look, this is a really simple matter, we just want it over yesterday. And it would be great if we could do it that way, but often life isn't like that. So I would recommend that you get some timely assistance, and I'm pretty much about strategies, how you handle things. Often a lot of separations are very, very stressful, and often you're in damage control. You want to get out of this situation as best as you can, as fairly as you can, minimize the damage, because if there are children, you're probably going to have to see each other over the years, especially if the kids are young. And so every case has its own intricacies. So, you need to take a long-term view of where you're going and how you want to play things out. So I hope, as I've said before, I hope this has been of some assistance, and I'm going to sign off now and wish everyone all the best. So, so long and farewell.